patent system in the US. We've seen lots of technological revolutions that have not really had much impact on the law or doctrine associated with the patent system. It's been pretty nimble in responding to technological change. And that's interesting to me because I can compare it to copyright law, where every time we've had a new copying technology, a new transmission technology, a new performance technology, we've seen significant substantive changes in copyright law. So technological change might have a big impact on the law, but it doesn't seem like it has with respect to the patent system. Today, we want to think about that sort of question with respect to AI. So our panel is going to talk about what AI might do to the patent system. We're going to think about 3 domains. We're going to talk about the impact on novelty and non-obviousness. We're going to talk about disclosure. And we're going to talk about prosecution and examination. 2 other topics that have been much discussed: inventorship and subject matter that's eligible for patent protection. I'm not going to ask the panelists questions about that, but during Q&A, if you want to bring up those kinds of questions, I'm sure our panelists will be able to talk about those as well. The reason we're not covering those is because the literature's already talked quite a bit about those issues. And we have more than we can cover in our hour anyway. So our panelists today are Lisa Larrimore Ouellette, who is the Dean F. Johnson Professor of Law at Stanford and a Senior Fellow at the Stanford Institute for Economic Policy Research. Next to her is Janet Freilich, who's a Professor of Law here at BU and will soon be a visiting professor at Harvard. They're both leading patent scholars. And to some of you, you might care that they've both presented in the past in the innovation session at the NBER Summer Institute. And if you like what you see from Lisa today, you can catch her there tomorrow. Peter Cuomo, who's at the end, is a patent litigator at Mintz, where he represented clients across a wide range of technologies, such as biotechnology inventions, automotive parts, medical and mechanical devices, and consumer products. And finally, Liujing Xing is a patent lawyer at Fish and Richardson, where she focuses her practice on patent prosecution, global patent portfolio strategy, strategic counseling for clients in the pharmaceutical and biotech industries. And we're fortunate she's a lecturer at BU Law, where she teaches patent prosecution. So a patent claim lacks novelty if it is identically disclosed in the prior art, and a challenger who can't show a lack of novelty might take different references from the prior art and combine them to show that an invention is obvious. So my first set of questions concern AI and the scope and content of the prior art. So Pete and Lisa, either one of you or both of you, publications must be accessible and enabled to be characterized as prior art. Does our understanding of accessibility or enablement need to change for publications generated by prior art? And so please help the audience understand what these terms mean in this context and what's at stake with respect to novelty and non-obviousness.
You can start.
Great. It's on? Okay. Yeah, so the prior art, as Mike said, it's stuff that happened before you file your patent that could prevent your patent from being granted. Currently, prior art needs to, it only will keep you from getting a patent for what it enables, meaning what it teaches someone in the field to do. So like if you're trying to get a patent on a hoverboard, the patent office can't say, well, there was a hoverboard in Back to the Future, and so that prevents you from getting a patent because, yes, it disclosed the idea of a hoverboard in the movie, but it didn't explain how you would actually create one to someone who's skilled in the field. Now, the issue is that prior art documents are assumed to be enabling, and so if you have a earlier patent or a paper or something about a hoverboard, it's assumed currently that this teaches people how to make it. And so all the patent examiner needs to do is say, well, your hoverboard has these elements and this earlier patent has these elements, and so your patent is invalid. And then the applicant could come back and say, well, it doesn't actually teach someone how to make that, but these rules on enablement can be challenging to actually show that something is not enabling. And I think that is going to be an increasing concern with AI-generated references. And the problem is not with the existing standards, is that we don't actually enforce these standards very well. There are not good ways for patent examiners or applicants to show that lots of things that are having patents granted on them now, lots of earlier patents, are not actually satisfying the legal enablement requirement of teaching someone in the field how to make and use it, because you can get a patent on something that you have not actually implemented in practice. So this has been a long-standing problem, but I think AI is going to suddenly make this a lot worse, because generative AI tools are very good at very quickly spitting out lots of ideas of, like, here's a very plausible sounding way that superficially sounds like it would make a hoverboard, even though I haven't made one. And if you had someone who's like actually a good engineer, they'd be able to explain why it doesn't work. So I think that is the policy concern, and that the solution is that the patent office is going to need to actually start enforcing this requirement, and both training examiners on how to think about the enablement requirement, both for prior art and the patents they're examining. And perhaps this presumption that things are enabled, we should be changing that for things where there's not evidence that it has actually been built.
Yeah, I would really agree with that. Enablement essentially means that you can make and use the disclosure. You don't have to engage in what's called undue experimentation. And simply assuming that generative AI content is enabled, I think, is something that really needs to change. That's kind of a thing of the past now, with all of these different kind of programs that can spit out disclosures that are then potentially part of the prior art and part of the landscape for patent practitioners and innovators to try and navigate. One question about generative AI disclosures is whether or not they should even count as prior art. And under the controlling statute, which is 35 U.S.C. 102, you don't necessarily need to be a human author to have created prior art. So under the law, at least, it's not completely clear, but it certainly seems that these generative AI disclosures are potentially prior art, and I've read about examiners starting to cite them during prosecution, and it's something that patentees and their patent practitioners have to navigate. Certainly the examiners seem to believe that they are prior art, but to Lisa's point, simply assuming that anything that is spit out, and we'll get into this a little bit later, by a generative AI program, to assume that they're all enabling, I think that viewpoint really needs to change.
So in our discussion, Pete, you use the phrase pump and dump, and you were worried that somebody's going to start pumping a lot of prior art out there. Who might be motivated to do that? And you want to tell us a little bit more about what you're thinking about that?
Sure. It's been in the news a little bit recently, but there are these websites you can go to. I think one is called All Prior Art. Another one is called All Claims. And these are people who are kind of hostile to the patent system. They're trying to kind of contaminate the landscape with these AI-generated disclosures. And what they'll do is they'll mine existing patent disclosures and then feed the information into an algorithm that then starts to spit out disclosures. A lot of them are just nonsensical and gibberish, but presumably some of them would be enabled. And what they do is they timestamp these and they put them on the internet, and they're trying to essentially put up barriers for people who want to gain patent protection. And one of the key questions about this AI-generated art is it readily accessible to an ordinary artisan? There's an assumption in the law that the hypothetical person of ordinary skill in the art has access to all forms of prior art that exists at the time of the invention. And now where you've got this smattering of, and you can go to these websites, you'll see there's just laundry lists of hyperlinks you can click to, and it's just one disclosure after another. Are we now still assuming that the person of ordinary skill in the art has access to that needle in the haystack, that enabling disclosure that is buried in this sea of, gibberish, AI-generated disclosures that any artisan would probably never even pay attention to? And I think, from a policy standpoint, do we really want to give these sort of zombie disclosure legs and use them, particularly in fields where artisans aren't really giving them much credence? Do we want to cite to them and use them to kind of, stymie the incentives for innovation and that people who are trying to get patents are really, interested in?
So, Liujing, do you have any, I think you might have some follow-up thoughts on accessibility and how AI can kind of intersect with this question that Pete was just talking about of accessibility?
Yeah, I completely agree with Pete's point there. I think a lot of these AI-generated prior art are not properly indexed, so not really searchable. The question is, I think a good question to look into is how much of the prior art is actually indexed, searchable, accessible to one of skilled in the art with reasonable diligence, and what kind of search tools should be considered available to that person with reasonable diligence, right? Presumably there are really powerful AI search tools out there that would enable you to locate any reference in the world, but can we assume that a reasonable person would have access to those tools? I think those are some of the questions that would be worth looking into from an empirical standpoint.
So, Liujing, anything else you want to say about the first general question?
I think I agree with the points that have been discussed so far in terms of that presumption of enablement. So under the current framework, like Pete and Lisa were discussing, a prior art is presumed enabled, and applicants bear the burden of proving otherwise during prosecution. And the framework was partly driven by practical concerns, right? Pre-AI, the USPTO doesn't have resources to test every single reference to verify whether each of them would actually work. I think AI exacerbates that problem and creates asymmetry because now the concern is the cumulative burden on the applicants to have to argue against large volumes of disclosures that are presumably non-enabling in the first place. So I think, and the AIPLA has brought up this point in its comments in response to the USPTO's request for comments, is that some existing doctrines might provide at least a partial answer to this issue, which is that currently, when a reference is not enabled on its face, so if it's facially non-enabling, clearly deficient in its disclosures, then applicants can actually rebut the presumption and shift the burden back to the PTO relatively easily by presenting just some non-frivolous arguments without supporting evidence. I think that principle could apply to a lot of these facially non-enabling AI-generated prior art. You would treat an AI-generated facially non-enabling art just the same as a human-generated facially non-enabling art. So I think it would be interesting to see if that, previously somewhat peripheral doctrine would become more important, and whether or not it gets more frequently invoked during prosecution, as we start to see more AI-generated art enter the system.
Janet, any comments on what we've covered so far?
Yeah, so I absolutely agree with what's been said already. One of the challenges is that the Patent Office can't actually evaluate enablement. And we've been talking about this idea that there's going to be argument over whether a prior art reference is enabling, whether a prior art reference teaches enough that someone in the field can make and use this invention or idea or disclosure without undue experimentation. The Patent Office has said, in the context of trying to deal with, is this piece of prior art enabled for purposes of rejecting a patent, the Patent Office has said, we don't have labs. We cannot figure out how much experimentation it would actually take to make this. And so the more this becomes a question that examiners have to deal with, the more challenging it is for examiners to actually have to deal with it. So you can fall back on presumptions. That doesn't entirely solve the problem that the Patent Office can't do this. So I think that is going to become more of a challenge. And then the second point that Liujing made, but I want to emphasize is there's an asymmetry here between, or there's a shifting or maybe increasing asymmetry, which is there's a lot of prior art out there. If it's presumed to be enabling, the Patent Office can say, well, there are these 1,000 prior art references that that can all be used to reject your patent. And then the patent applicant has to go through one by one and give a detailed argument for, actually, this is why they're not enabling. And that's a lot of work, and that really drives up the expense of prosecuting a patent. And so it may be that we need to shift how we think about these presumptions to avoid that problem where it's the patent applicant who's always having to give this detailed rationale for why a prior art reference is not enabling.
All right, so I wonder, Lisa, go ahead.
Well, I just wanted to dissent on the reasonable diligence standard and to just add some nuance there. I mean, so there's two different legal issues that we've been talking about here. So, like, one is the question of, is a given reference, does it count as a printed publication that we can think of as prior art? And then there's the question of, like, is that enabling? Because it's only prior art for whatever it actually enables. And we talked a lot about why the enablement issue is hard for the Patent Office to understand. On the first question of, like, should it count? So, like, one way to think about it could be that fewer of these things should count because you couldn't access them with reasonable diligence. But, like, that is not the way. That is not the current standard for whether something should be, whether a printed publication should count as prior art. And I think it's not the current standard for good reason. Like, it might sound unfair that your patent is denied based on something that a diligent person wouldn't have found, but it has long been true that a very obscure publication that is just one copy of a dissertation in a library in a foreign language, or one conference poster that was at some conference in your field that, like, you was in some other country, you wouldn't have been likely to be, like, those count as printed publications that can prevent you from having a patent. And I think the justifications for that are, one is a reliance interest of the, like, whoever wrote that dissertation, whoever made that poster, like, they did create this invention before you did, and they should, and whoever else found that should be able to continue doing this without you getting a patent on it later. And then also the fact that someone did it before is some evidence that a patent is less necessary to induce the innovation in the first place. So that's why it's not a standard of, like, could someone find this with reasonable diligence. Now, those rationale may not apply to the same degree with a thing that was simply automatically, algorithmically generated. No human has ever actually read it or relied on it, and it's not evidence that they have made it. And so, like, maybe you need to think about that differently in the AI standard. But, like, I think we definitely don't want to move to, in general, a can you find this with reasonable diligence standard for prior art.
So for the panel, I'm going to offer 3 questions. You can comment on any of them if you want to. 1, there's an analogous art doctrine that applies to obviousness, not to novelty, that says that we've got this big basket full of references, but only those that are in the same field as the invention or those in an analogous field can be used for obviousness. So the question is, does AI change how we think about the scope of what is analogous art? Question number 2, do you have any empirical questions you'd like our audience members to answer? And question number 3, back to the pump and dump. I want you to cast dispersions. Who's out there, Pete, or anyone, who finds it in their interest to invest in the activity of filling the world with prior art references?
I could start with the last one. I don't actually know who's behind all claims and all prior art. I think these are mainly groups of people who, like I said, are hostile to the the patent system, but they are prolifically creating prior art. And to the point where that was made earlier about the onus being on the patentee to show that a reference is not enabling, that's a high bar at the patent office. I've tried to make that with the support of expert testimony at times during post-grant proceedings, and the office is really, in my experience, reluctant to accept that position unless you really have compelling evidence. So when you combine that with the way that these AI-generated disclosures are being put together, I think it's a real problem. To Lisa's point about accessibility, she's right. In the world that we lived in pre-AI, that thesis that's buried away somewhere that is publicly available would be considered prior art. But that was made by someone with good faith intentions who, obviously was trying to innovate and report their findings to the broader scientific community. That's really not what's happening now with, some of these outfits that are just cranking out disclosures.
I'll go with. I'll answer not that question, so maybe I'm not the best person to go next, but the empirical work question. So there's so much empirical work to be done here if anybody's looking for projects. I think that counting the number of anticipation rejections, so has that gone up? Are there more patents being rejected on anticipation grounds for lack of novelty? And does that seem to have really gone up since, let's say, 2023 or so? Interesting question. And then also, do we see patent applicants responding with arguments that the prior art is not enabled? So what we've been talking about here is the patent applicant can potentially argue back and say, examiner, you're wrong. What's actually, this piece of prior art, there's nothing underneath it. It's just somebody made a picture of a hoverboard or a movie about a hoverboard, but there's nothing else. And do we see that argument being used more by applicants, and is it successful or not? Will be pretty interesting questions right now and in the coming years.
I agree with that. I mean, there's tons of interesting empirical questions. The hard part is that the things that we really want to know are just very hard to establish empirically. Like I would like to know how many prior art patents are enabled, but that would be hard to empirically assess. I think you could actually. I was going to ask Janet if she wanted to work on. I'll invite you on this panel too. A follow-up project. One thing that we don't have great evidence on is even how many existing patent prior art documents are based on actually reducing something to practice versus purely they were just sitting there and came up with an idea, but they haven't actually done anything in the real world. Some of the only empirical evidence we have on this is Janet's work, where she looked at examples of these prophetic examples in patents where it's based on the verb tense that you're using that distinguishes between whether it happened or not. And because she was doing this pre-AI tools, this is based on kind of other algorithmic ways of looking for the things that are specifically labeled as examples and finding the tense in there. I feel like with some of the existing generative AI tools, we could update that with patents that aren't in the biotech area, and that would be fun.
Cool project. Let's talk about it.
But yeah, there's other things like that are related to this. The ultimate thing we care about of how much of this is actually enabled, I think would be super useful.
I'll make a quick comment on the analogous art doctrine. So I think this one will be interesting to watch because even pre-AI, and especially after KSR, I think the doctrine has really lost, it's sort of a low average bite kind of argument to begin with. The idea is that, if the art is not from a related field, if it's from a completely unrelated field, as long as is reasonably pertinent to at least one problem the patent is trying to address, it would be considered analogous art. So it's sort of been applied pretty flexibly already, and I think the fact that AI can bring in more art from unrelated fields may just expand the space of analogous art. I think that's possible. But on the other hand, the doctrine asks whether it's not whether a reference can be brought to the attention of the researcher. It's whether the researcher would have considered it relevant to solving the problem at hand. So even though the AI may be able to identify more references, if the researcher still wouldn't have considered, a solution from that particular reference, I think, there's an argument that that is not analogous art. So I think it'll be interesting to see how this area of law evolves over time.
Okay, let's move to our second domain. We talked about what's in the prior art. Now we're going to talk about how does the non-obviousness analysis change, if at all, when we introduce AI. So Lisa, the non-obviousness doctrine can be formulated in terms of a cognitive test. Wow, as an editor of a journal, I think that's pretty impressive. Or it can be formulated in economic terms. A patent was needed to induce this investment. How do those two approaches work when we introduce AI?
Yeah, so the way courts have most typically formulated the doctrine is in terms of this cognitive question. So the question is like, for this hypothetical ordinary researcher in the field, someone who has ordinary skill in whatever the field is, like, would they think it is obvious to put the prior art together? And it's usually described in terms of this, like, how hard would they think it's cool or not? There's some language in the cases, including one of the famous Supreme Court cases, this Graham versus John Deere case, that's like the point of obviousness is to have patents to weed out things that you don't need the patent for, like to only give patents on things that wouldn't be created or disclosed but for the inducement of a patent, which is a very economic way of thinking about it. That, like, the whole point of this doctrine is to do that cost-benefit analysis to make sure we're only, as a society, dealing with all the costs of a patent in the cases where it's worth it for the innovation benefit. And I think that underlying economic policy underlies a lot of what the courts have done in these cases, even though they describe it in terms of the cognitive approach. And I think that AI will provide a additional reason for courts to do that it kind of exacerbates the problems with this formal cognitive framing, because with AI-based predictions, like, even more things will be obvious to try and have a reasonable expectation of success in the way that courts have thought about it, even though there are many things for which, like, due to the commercialization costs, like, even if it is obvious to try, no one is going to do it unless they have the exclusivity of a patent in certain fields. And then there's other things in which, like, you really don't need the patent to have it. And so I think the rise of AI invention will create an additional reason that courts ought to be more explicit about the kind of thing underlying the doctrine, which is that, like, this should be a economic cost-benefit analysis.
Great. Other three panelists, courts sometimes create rules of thumb to deal with this difficult question of obviousness. So for the benefit of the audience, some examples Lisa's already mentioned. Obvious to try. Was there a reasonable expectation of success? Did it result from routine optimization? Would an inventor be motivated to combine these pieces of prior art? Was there an unexpected result? I'll invite any or all three of you to comment on how might AI change these sorts of, or the application of these rules of thumb that are used in 103 analysis.
I can start out with that one. As Lisa mentioned, courts look at the hypothetical, person of ordinary skill in the art who, has access to all of the relevant prior art. I think now they have to realize that that person is, an ordinary artisan who also has access to generative AI and other AI tools. And, how does that change the equation in a given field? I think this is going to be very case-specific and context-dependent. And, in my opinion, I think there's a lot more room for experts to opine about how AI has changed a given field and how you define that ordinary artisan and the tools that they would have access to and use. And so I believe that, at least in the judicial system, we have what's called the battle of the experts a lot in patent cases that often are determinative of the outcomes. I think that's going to be even more enhanced now as they opine on how an artisan would use generative AI tools.
I can talk a little bit about obvious to try. So that rationale is strongest when there are, and I think the terms were finite number of identified solutions that are predictable. So when the court says, you only have 5 options here, and they all seem to, have, a likelihood of success. So someone in the field would, reasonably wanted to try all 5 of them and figure out which one works. So when it's obvious to try, then it's likely that the invention is obvious. I think that from a life sciences perspective, even with AI, I think that doctrine still can provide some sort of a safeguard because life sciences innovations are very much constrained by biology, which is inherently unpredictable. So even though an AI model may be able to, tell you these are the 5 top candidates, it still, at this point, can't predict whether either of them will actually have the required function, therapeutic effects, toxicity in an animal or in a human body. So I think the key question still is, experimental validation, whether or not the patent has been able to demonstrate with lab testing that these candidate molecules would actually work. In that sense, I think, AI may be able to reduce the number of candidates, right? There is a finite number of solutions, but it may not be a list of predictable solutions. So I think that's something that, at least in life sciences, would be interesting to see whether or not that doctrine still provides a safeguard against AI-generated art.
Building on that, AI makes it, in some sense, cheaper to come up with ideas. It can give you a list of, here are 1,000 different combinations you can try, but it doesn't change the rate at which it becomes cheaper to the same extent to test those ideas. It might make it a little bit cheaper, but it's not going to make it much, much cheaper the way that it has for generating ideas. And the patent system is oriented towards these early stage idea and maybe a little bit more than idea developments and less towards physically testing and figuring out what's actually happening. And there are many ways in which patent law reflects that orientation towards early stage inventions rather than later stage testing. AI might shift the balance for what makes sense, what it makes sense to think about in terms of what are we rewarding, this early stage coming up with the ideas versus this later stage testing. And then an empirical question or field of questions that some of you are working on that I think is very applicable to questions of what is obvious is the science of science inquiry into how do we invent? What does it mean to invent? What is it that creates these great inventions, these combinations of ideas? Because it's probably not AI coming up with 1,000 different possibilities, but I don't know what it is, and there's lots of great literature that is trying to figure that out. So that's going to be very relevant to how 103 develops.
Okay, I want to move our discussion to disclosure, unless someone wants to jump in with something else. Okay, Janet and Lisa, ideally a patent disclosure conveys valuable technological information to the world, and it can be used within the patent system to make sure a claimed invention works and that the patent isn't claiming too much, more than the inventor deserves. So how is AI going to affect these sorts of doctrines? And note to the audience, we talked about enablement with respect to prior art, where the patent applicant wanted to make sure stuff was enabled. Now we're going to talk about the examiner and the rest of the world wanting to make sure that these patent applications that are going in, that the claimed invention is a real invention.
Sorry, I just want to reiterate points that Janet made earlier that are relevant for answering this question. So the point that patent examiners are not good at assessing enablement, that's relevant here. The point that the patent system tends to reward early stage coming up with ideas rather than the like work of figuring out what actually worked. That's relevant here. I'm not sure that AI changes what the patent system should be doing. I think it exacerbates an existing problem with the patent system here. I think it is a problem. I mean, it's ultimately an empirical question, and it's like hard empirics here, but like my sense is that the way the patent system rewards early stage idea generation without having implemented something in practice, and often when you like don't have like it is hard to implement something in practice, that is a problem that can then block the later inventor and decrease incentives to figure out what actually works in the real world. So that's not a AI specific problem. That is a long-standing problem in the fact that we give these patents based on armchair inventing without actually implementing something. AI will simply make that problem much worse because it is very easy with AI to quickly generate a very plausible disclosure. I did a test of this for a small paper a year or so ago with a former patent examiner and a expert scientist who happens to be my husband, coming up with a few different inventions, both things that already exist and things that do not yet exist, but it would be nice if they did, and use various generative AI tools to generate a specification. Like there's lots of tools you can now say, I want to have a hoverboard, like write a specification for this, and it will spit out a long specification describing all the details of how you make a hoverboard. And so it did this for a bunch of these things, these existing inventions and not yet existing inventions, in a way that to me and to the former patent examiner would get past a patent examiner, that they're like facially plausible. It takes like really thinking about it and digging into the science at a level patent examiners are not doing to figure out what's wrong with them. But to an expert in the field is like obviously wrong. And so we need examiners to start doing more than that facial looking at it and think about like, does this actually make sense, and figure out how to build that into the patent examination system. And for a separate project, I interviewed a bunch of patent examiners and litigators about why we don't enforce these enablement requirements in either context now. And I think there's a bunch of structural institutional factors related to how patent examination happens and the incentives litigators have, that this is just under-policed, under-enforced, this requirement that in order to get a patent, you need to disclose how to make and use it to someone who's an ordinary researcher in this field, and we need to figure out how to start enforcing that.
Yeah, it's a very, very cool study looking at how AI might change disclosure. One of the problems, AI, of course, makes it much easier to disclose lots of stuff. This is already a problem in the patent system. You can look at pre-AI patents in, say, life sciences, and you can see, I'm sure not ones you wrote, and you can see examples of, here's a molecule I invented, and it can be used to treat, and then there'll be a list of 1,000 diseases. And not tested, and sometimes there's even more than that, more detail, and AI can just make those longer. And the challenge is it's a way of burying the useful information, if there is any, in a whole bunch of other stuff. And so one way that I think the patent system needs to adapt in terms of the disclosure requirement to AI is having more rules about disclosing the quality of disclosure. Because somebody reading this patent, even an expert in the field, there's a lot they can't figure out about what's been done and what hasn't been done and what details to trust and what not to trust. So more disclosure about disclosure, more information about either I actually did this experiment and here are the conditions under which I did it, or I didn't. I had an AI model maybe run this for me, which might be great, but we need some information, the reader needs some information about the parameters of that model to evaluate whether this is a prediction that is worth anything or whether it's garbage. And so additional information about disclosure, and then there's a requirement that's called best mode, which is a requirement to disclose the best version of the invention, essentially. It is ineffective right now because it was so hard to enforce that as of about 15 years ago, a statutory amendment essentially said, well, it just can't be enforced in litigation anymore because it's really hard to figure out. Recognizing those difficulties, I think AI makes it much more important for the patentee or the patent applicant to specify which versions do you actually think are the good ones versus which versions did you tell your AI system come up with 1,000 of these. That's important information for the reader, and the patent system could do more to require the applicant to delineate between categories of reliability in terms of information.
Liujing, you want to dig deeper into life science inventions and disclosures?
Yep, happy to. So in terms of life science, I'll talk about, how life sciences research kind of where it's going based on sort of talking to, former classmates of mine and people in the field, is that people are thinking that the AI models are sort of shifting the bottleneck, where kind of to Janice's point, generating hypotheses and candidate molecules are becoming much cheaper and much easier, but experimentally validating them and selecting from those candidates are becoming more valuable. So it's sort of becoming an iterative process where AI comes up with hypotheses and candidates, experimental testing, identify which ones actually work, and that information gets fed back into the model to improve it. So I can see the disclosure kind of following the same pattern, where we're going to start to see broader and more detailed disclosures, just because AI can identify more candidates and computationally predict a lot of information about those candidates, right? Where do they bind? What are their structures? And on its face, the disclosure will look really detailed, but whether or not there are experiments in those disclosures actually testing those candidates, I think will be critical in terms of satisfying the current enablement and written description doctrines, at least in life sciences, which I think is getting more strict over the last couple of years. And I also think that there is one unique issue with using AI models to predict candidates. If it's practicing the invention actually hinges on utilizing those models, then you may need to include information about the prompts and the inputs and the criteria, what specific model you're using. That's going to be a new section of the disclosure where we talk about the AI part of the invention.
Yeah. Okay. Anyone, Pete or anyone else, have any comments? I'm going to move on to examination unless someone has. Okay. So we're going to go maybe another 5 minutes, and then I'll open this up for Q&A. So last domain that I promised that we would talk about, this one's going to be a little bit shorter, I guess. AI is clearly having an impact, we already heard, on the way that applications are prepared, and it has an impact on the way examination is working. So Liujing, why don't you start as the patent prosecutor here? Tell us some things that we should know about what AI is doing to patent prosecution and patent examination.
Sure. From the prosecutor's perspective, we definitely are starting to integrate AI into our workflow. And I would say it's primarily in the patent drafting and the prosecution, the two main domains of a patent prosecutor's practice. In terms of drafting, I see it being most valuable in the earlier stages where AI is helpful in terms of organizing disclosures, helping you understand the prior art space, a good summary of the prior art out there. It's not currently, I wouldn't say it's ready for automatic patent application drafting just yet. You still need a lot of strategy and scientific judgment when you are putting together a patent application. I think the AI models right now are just not quite there yet. In terms of prosecution, I've used it to summarize office actions, evaluate examiners' positions, again, review the cited references, propose some initial arguments. But there are definite limitations. Sometimes AI will propose an amendment that is not supported, for example, by the specification. Or it will have missed some important scientific distinction that is very nuanced. So I think from a prosecutor's perspective, it's definitely facilitating our work. It's not completely replacing our judgment and the scientific understanding.
That last point is good to hear.
Yeah.
Lisa?
I'll just say that in the examination context, the Patent Office has been experimenting with some AI tools for over 5 years, but not in I think the main problems are, one, that they're tools they're using are often not the latest things, somewhat outdated, and two, they've not been willing to experiment with any of this in a way that allows any evaluation of what's going on. I mean, the agency is I mean, they've been admirably interested in doing policy experiment, or not. They describe them as pilots and things they test various things, but they don't actually test any of them with any kind of evaluation strategy, so that you get to the end of a pilot and you're is that a good pilot or not? So I think there's lots of empirical work to be done in this area, including by the agency themselves, and figuring out ways to have them be more excited about doing that would be great. They did do one RCT, not in the AI space, that was largely by accident, because they didn't run it up the chain and someone just did it, but it was that was great, and I and others have given them lots of praise for having done a RCT that was useful. So I'd love to see them do more stuff like that.
Pete, Janet, any comments on examination or prosecution?
Not on examination or prosecution, but I can talk about some of the litigation AI
Okay.
tools. If you're evaluating a patent, if you want to try and potentially invalidate it or even just assess the strength of it, there are tools now where you can put in the patent claims into the program and then just add whole pieces of prior art. And the program will generate a claim chart that accounts for all of the different limitations in the patent claim. It'll give them a score with comments. It will also assess the motivation to combine. It will point to, let's say, dependent claims where you might be missing a limitation and you need to account for that, and you can add in another reference. Or you can just take out one of your sort of primary or secondary references, plug a new one in, and have it reevaluate those against your patent claims. And this all happens very quickly. I mean, this was something that would take an associate, days to maybe a week sometimes to mine and evaluate and read the prior art disclosures. And these programs can do it almost within a few minutes. And so, like everything that generative AI puts out, you have to carefully review it and edit it and make sure that it's not suffering from any kind of hallucinations or other infirmities. But it's been a really powerful tool. We're just sort of scratching the surface of it now, and there's a lot of groups out there that are starting to push out these tools. One of the ones that we use was put out by a former patent attorney at a big AmLaw 100 firm who had worked for Dell and I think understands what's happening, which I don't, in the background with the algorithms that are being applied. But it's really streamlined the ability to assess large combinations of prior art, whether you're trying to assess the strength of a patent or, again, if you're trying to invalidate it for some reason.
Great. Janet, any final comments?
So absolutely to randomized control trials at the patent office, for sure. Examiners are really time constrained. That's a well-known problem. It's been well-known for a long time. So working with AI to try to speed things up or to make things more efficient seems really promising. And it's probably a good thing to incorporate.
Great. All right. Thanks, folks. Questions?
An idea, possibly a silly one. So the requirement of obviousness has always been time dependent or technology dependent. The skill of the tradesman depends on location and what else there. And maybe we should embrace the idea that now everything that can be generated by AI is simply obvious. And maybe we should really be focusing on usefulness or enablement. We just accept that a patent should be granted if you bring a model or prove that, or provide the experimentation. Let's move the concept of a patent towards a more pragmatic and developmental stage rather than early stage transition. How silly would that be?
I mean, there's legal scholars who've written that article saying everything should be obvious now with AI tools. I mean, I think from my perspective, I think the role of obviousness doctrine is to do this economic cost-benefit analysis, to have it so that we're only granting patents on the things where the benefits society are getting are worth the cost. And I don't think that this kind of cognitive approach to including like, I mean, there's things that AI can quickly come up with a drug candidate, but it could be that if you don't have a patent on that drug candidate, like no one's going to develop it and commercialize it. And there's other tools you can also use for that, but or maybe we should be heightening the disclosure requirements and how we're thinking about that. But it's not obvious to me that simply because AI came up with something that we necessarily don't want to have a patent on it from a economic cost-benefit sense.
Other panelists want to respond?
It's a tempting idea. It's a very big change from what we have now. And I've written a lot of articles on how these early stage ideas shouldn't always be patentable, but I also absolutely see why there are reasons for them to be patentable, and it's really hard to empirically get a good grasp on what the patent system is doing and when we should have patents and when we shouldn't. And so, people in the room, if you can answer that question, that would really help us figure this out. So I don't know. I don't have the empirical answers to really have a good grasp on that.
If I can just add a follow-up. Right now, it becomes very cheap to do one part of the inventive process, which makes the other part of the inventive process more valuable. Maybe we should promote it. It's a purely economical argument.
So
And it's related to why Janet and I have both said we should push
got Adam and Joaquim and Jorge. Adam?
Well, I have about 6 I'd like to ask.
Well, why don't you ask 3? And
Mike, in your introduction, you comment on the fact that as technology and the technology of innovation has changed, the patent system has seemed to not change very much. And I don't think there was a normative inference in what you said.
Right,
but
right.
It made me think, and wonder, well, is that a good thing? And then I was struck by, in many of the examples that we talked about, several of you said, well, this problem has always been there. AI is only making it worse or making it more obvious. So my question is, what are the prospects that as AI makes some of these known problems worse or more obvious, that we might actually change law or practice to actually fix or get rid of, maybe by changing the whole system? I mean, is it going to change?
Maybe.
It's traditionally been very hard to make changes to the patent system. I'm not optimistic.
I'm more optimistic.
I would like to see the patent office use some of these generative AI tools in their day-to-day practice to make outcomes more consistent, particularly where you've got similar disclosures, treat them the same way. Maybe even have the machine generate a first draft of an office action to free up the examiners and reduce the backlog more, but also to just increase the consistency of results coming out of the office, because to the financial stakeholders behind the patentees, that's probably one of the more important aspects that often gets overlooked.
So Rena, did you want to follow up, or should I put you in the queue?
I would follow up, which is, doesn't this also have huge implications for TPRI?
Can you say it a little louder, please?
For PTAB as well. So wouldn't you, because that's really the release valve, right, for much of this, or potentially one of the release valves.
I mean, the politics, so the PTAB is the kind of appeal board within the patent office. So there are administrative judges who they hear appeals from examiners. And then also you can file these post-grant challenges to patents. Anyone who's been following the patent office, there's like a huge controversy right now because over the past year, the administration has made it much harder to institute these challenges after a patent is granted before the PTAB. So, I mean, the political future of that is unclear to this question about like what is feasible. I mean, but the different avenues for any of these interventions, there's like what the examiners are doing on the front line. I think there's things that can happen there, and there's how easy we make it to challenge things before the PTAB and what tools the PTAB has access to, and I mean, including on the disclosure front, which we've talked about the importance of actually enforcing this. Like right now, you can't have one of these PTAB challenges, like the main ones more than 9 months after a patent is granted, that raise the disclosure problem, even though I think the PTAB judges are often better situated to evaluating this disclosure issues than a jury or a judge. And so maybe that's a policy change that can, and at some point there might be a political coalition for that to happen. Yeah, so I think a lot will depend on like what the next administration is and what their approach to patents is.
I do think that AI tools will make it easier to challenge patents because it's easier to find prior art. So it's easier to bring those anticipation and obviousness arguments, and that affects the PTAB as much or more as it affects litigation, assuming you can still bring challenges at the PTAB.
Joaquin?
Should I use a mic or for the recording, or how do you do this? So let's come back to this point of mass dumping. AI creates inventions, and you call them zombie disclosures that contaminate the patent system and tiny incentives for innovation. And I disagree. I mean, at least one can put it that way in some areas. Maybe not so much pharmaceuticals, but obviously it was not that difficult to create these things. And I mean, what we have today is that the world is flooded with patents that are too easy to create. And where, Lisa, you made the point that maybe you wouldn't have needed a patent to create these things in the first place. Exactly. Also relates to what Tommaso just said. To give you an example, 2018, the French ride-sharing platform BlaBlaCar, which is, I think, quite successful in Europe, they said, no, we're not going to go to the US. Among other things, Apple had a patent on, what was that, a social tool for ride-sharing members of a social group. It's like a stupid idea. I mean, not stupid, it's a simple idea. It's just that implementation is the trick. But if then Apple comes along and says, give me money because you implemented our stupid idea, this is flooding, and this is actually more contaminating the innovation system. I would flip it around and say, most or many patents at least are contaminating the innovation system. So, and these AI invented things help to get rid of some of those maybe.
Yeah, I think in some ways the AI systems might even exacerbate the problem that you're talking about, and it was touched on by my fellow panelists about prophetic disclosures and just, maybe the volume of patents in general that are being sought and obtained. I think, the point with the all prior art and all claims, those outfits, they're really not generating true ideas. The machine is just repackaging old parts of prior disclosures that did fit together and trying to reassemble them in a way that they do create some kind of disclosure or idea, but most of the time they're missing the mark. And so what they're really doing is kind of flooding the space with these often just gibberish disclosures that don't mean anything to anyone. And in that way, trying to put that up as kind of a barrier to the patent system, I think, if we give that credence, and I do think they're kind of zombie disclosures because there's no real actual thinking person behind them. There's an algorithm that doesn't know if they make sense or not. And, we could obviously disagree, but I just think, we should be prioritizing the incentives for innovation, which these are a big threat to if we actually, give them credence. And I would encourage you to go and look at these websites and just see how much I'm talking, the volume that I'm talking about.
Point, if I may. I mean, as also Lisa said earlier, the whole world is prior art. And I mean, what these AI things are generating is still tiny compared to everything that's out there that is valid as prior art. So it's just added. And if you say they're just adding up existing claims, putting them together, well, if that's just so trivial, then they shouldn't prevent any patent. But if a patent on these trivial things potentially would have been granted, then maybe the patent was wrong and not the gibberish disclosure.
Okay, I'm going to let Joaquin have the last word. So we get sorry, Pete.
Yeah, I think
Thank you.
I think my question is also related to the issue of prior art, and I'm wondering if is there like any legal argument to treat different pieces of prior art differently? Like if it's prior art from a patent, that's different from prior art from a paper, then different from prior art from this website.
Not in the current doctrine for printed publications. There is a difference for real world prior art. So if you're actually selling the hoverboard, then you don't have to. That doesn't have to be enabling. The fact that it exists and being sold, that's enough. But for printed publications,
But my point is, should we have a system where you distinguish between what piece of prior art is?
Maybe. I mean, I think we should be actually enforcing the enablement requirement for all of it, including all these patents that aren't actually enabled.
All right, thank you.
So we have a 20-minute break.